Marine Energy Trade Note September 2011 issue. The Marine Energy and Trade Team publish a regular newsletter, the Marine Energy and Trade Notes, in which recent legal developments are reviewed, new case law, changing legislation, and new areas of potential liability. The notes cover both UK and overseas news. In this issue, MET notes examine the following. Court rules on the meaning of a 100% notation in an energy reinsurance policy. Two different views of the meaning of the term 100% in an energy facultative reinsurance policy were examined by the Commercial Court. The judge confirmed the traditional view held in the energy insurance market, according to which the term 100%, whether contained in the original insurance or reinsurance policy, referred to the total insured value of the original asset, where the original insured held only a partial interest in that asset. What does 100% mean? The Commercial Court was asked to consider this question in the context of a notation on an energy facultative reinsurance policy. The answer, it turns out, is that 100% has a specific and generally accepted meaning in the energy insurance market. Incurred Marine versus Lloyd's Tunnicliffe on behalf of all other members of Lloyd's Syndicate 780 for the 2005 year and others 211. The claimant, Guard, has subscribed a 12.5% line on an energy package policy taken out by Devon Energy Corporation, which was subject to a limit on cover for named windstorm in the Gulf of Mexico of $400 million. Any one accident or of occurrence reflecting the fact that Devon had interests of varying percentage in a number of Gulf of Mexico wells and platforms. Guard insured its exposure under the Devon package policy with various Lloyd's syndicates, including Upton, the defendant in this case. The reinsurance policy expressed the sum insured in the following term: to pay up to the original package policy limit or amounts or sum insured excess of $250 million, 100% any once occurrence of losses to the original placement. Guard settled certain losses under the original policy and made an onward claim under the reinsurance. When the reinsurance claim came to be adjusted, a dispute arose as to the meaning of the reference to 100% in the reinsurance wording. Guard contended that it meant that the excess point is based on the total insured value of the original loss asset and not just Devon interest in the original loss asset, so that each indemnity paid by Guard to Devon has to be grossed up or scaled proportionately to Devon's interest in the asset. Advan took a different view, arguing that the reference to 100% was to be construed as referring to losses of $250 million to the full market of insurers on the original policy, not just Guard's 12.5% participation. The Commercial Court still accepted Guard's contention that in the market for insurance of offshore energy risk, the notation 100% has a specialized and recognized meaning when used to qualify limit or deductibles, irrespective whether used in an original policy or policy of reinsurance. It denotes that the limit, deductible, or excess point scale for interest, so that the excess point in the sum insured clause in this reinsurance policy was based on the total insured value of the original loss asset and not Devon interest in the original loss asset. Set of rights applied in separate financial transactions. This case addressed, amongst other things, the question of whether a right of set-off in respect of sum owed under an ISTA agreement could be exercised against sum due under an unrelated letter of credit. The defendant, Kellyan, issued an English law-governed letter of credit in connection with derivatives trading contract in favor of LBCS, which, when drawn open, was for the sum of £50 million 1 year prior to issue of the LC. LBCS and Kellyan entered into a wholly separate contractual relationship governed by a distinct ISDA-Master Agreement (IMA), which was subject to New York law. Section 6.f of the IMA provided that in the event of a default, there would be a right to set off any obligation of Kellyan owed to LBCS against any obligation of LBCS owed to Kellyan, whether or not arising under the IMA. An event of default under the IMA arose upon the filing by an LBCS group holding company under Chapter 11 of the U.S. Bankruptcy Code. This in turn gave rise to a debt on the part of LBCS of $15 million under the IMA. Consequently, once LBCS sought to draw down on the LC, Kellyan set off an equivalent sum to the owed under the IMA and paid a balance to LBCS of only £38 million under the LC. Issue. A number of preliminary issues were ordered to be tried, most of which turned upon question of U.S. law and the impact, if any, of the applicable bankruptcy law in New York. These were readily disposed of, leaving as the key issue the question of whether, on a proper construction of the IMA, Kellyan was entitled to set off sum owed to it under the IMA against the amount payable to LBCS under the LC. Discussion. There is little authority on this area, primarily because in most cases it is relatively unusual for there to be a pre-existing contractual relationship between the paying bank and a beneficiary under a letter of credit, such as to enable the bank to raise a claim for set-off of the authorities. Where there has been an underlying commercial relationship, set-off has usually been possible because the letter of credit arose from the same underlying transaction in respect of which there was a liquidated debt. In a leading judgment on this point, which arose out of a summary judgment application, the Court of Appeal took the view that it would be unjust for a bank to have to pay under a letter of credit where it had a real prospect of succeeding on a claim on the underlying transaction, particularly in the case of a liquidated claim. In LBCS and Kellyan, expert evidence on New York law was adduced to the effect that the word of any obligation in Section 6.f of the IMA were said to be broad, unambiguous, and included obligation owed under an LC.